All right, good morning. Welcome to the 294th District Court. I am Judge Chris Martin. Please keep in mind while you're in the courthouse, we want to maintain social distancing rules and regulations. I see that you've kind of spread out throughout the courtroom. Please continue to do that. Be mindful and conscious when you are in the hallways and in the elevators and the restrooms to maintain that social distancing. If you would like a mask and you do not have one, one can be provided for you. If you'll just ask the court staff, we can make that available to you. And at all times, make sure that you are washing your hands and maintaining your cleanliness. Okay, I'm going to go ahead and call this morning's docket. If I say your name, please raise your hand, say present or here so that I can acknowledge your presence. Francisco Zanella. Francisco Zanella. He's outside. He needs to be inside. Who's he outside with? Probably the attorney. Well, why don't you go ahead and step out there and tell him that I've called his name. Jacob Howell. Thank you, Mr. Howell. Deshelle St. Mary. Thank you, Ms. St. Mary. Ricky Allen. He's here. Hunter Huggins, I'm sorry. Tristan Lane. Rosalind Taylor. Thank you, Ms. Taylor. Tanya Red. Is Tanya Red here?
Judge,
go ahead.
I'm sorry, Your Honor. Judge, I received a telephone message this morning from her boyfriend indicating that she has been admitted into the hospital with potential heart issues. They're doing some testing right now.
Okay. Do you have any medical evidence or proof of that?
No, Judge, I got the first message from him, I think was about 8:30. You look real quick. And I was on the way to the office and I haven't had a chance to do anything other than get here and get logged on. So. Okay. And is Brett the only client you have on today's docket? It is, Judge. And although I haven't had an opportunity to verify that, I will tell the court that it was my understanding after the last hearing that we had on Miss Red, I guess it was a couple of weeks ago, that she was taken, I think, by ambulance from the courthouse to the hospital in Tyler with similar issues. But as far as today, I haven't had a chance to do anything and get any kind of records to verify that. Okay, then we'll do this. Then I'm gonna have her name called. If she doesn't appear, then I will take a nice eye and alias capias under advisement until 5 p.m. tomorrow. I'll give you some time to submit to the court any kind of medical documentation to prove her absence. Yes, sir. So I'll do that. All right. Thank you, Mr. Green. All right. Thank you, Your Honor. Joe Tubbs. All right, Mr. Tubbs, Mr. Head called the court, indicated he's stuck in road construction. Well, never mind. Mr. Head's here.
I am present.
Okay, good. Sorry. Okay, good. I didn't see you over there. So Robert Kane. And sir? Okay. Mr. Tubbs, I'm going to have you report to pretrial release to sign the amended conditions of pretrial release, and the motion that you filed, Mr. Head, the court is going to grant that. So Mr. Head if Mr. Tubbs will meet with pretrial release, then go ahead and sign those conditions before the hearing.
Yes, sir. Thank you, Your Honor.
Emmett Hernandez. Have you seen Mr. Hyde at all? No one see Mr. Hyde?
Judge, I spoke with Mr. Hyde yesterday afternoon. He and his client should be here. I think we have a resolution this morning.
Okay, we'll see if they both show. Cruz Martinez. Mr. Nicholas, have you seen Mr. Hyde in the hall? What about your client, Mr. Martinez? Not yet. James Robert Wynn. Mr. Wynn? Johnny Wayne Brown, is that the issue we want to talk about, Mr. Schmidt?
No, Judge, he should be reporting by Zoom unrequested.
I recall that, and maybe this is Mr. Brown here. Is this Mr. Brown? Yes, sir, please. All right, Mr. Brown, can you see me okay?
Yes, sir.
Okay, good. All right. I just called your name. We'll call your name again in just a moment and we'll have that hearing, okay?
Okay, thank you, sir.
You're very welcome. I'm just acknowledging you present on the docket.
All righty.
Alfonso Hendon. Thank you, Mr. Hendon. Stephanie Lenartz. Austin Banks. Austin Banks. Christopher Booker. Ms. Thompson, do you know any updates on whether or not?
Your Honor, he was, yes, sir, on July 20th, he was mailed a waiver. They contacted me, I believe it was yesterday. They did not send the waiver back, and I told his, I guess, girlfriend, he had to be present in court. The letter also directed that if he didn't mail the waiver back, he had to be present today.
All right, thank you, Ms. Thompson. Christopher Glenn Booker. Just so you're aware, Ms. Thompson, Mr. Booker is not present in the courtroom. We'll see if he arrives.
Okay, Your Honor.
Montrell Mackey. Thank you, Mr. Mackey. All right, is there anyone's name that's in the courtroom that I've not called? Mr. Martinez is here. Thank you, Mr. Nicholas. All right, keep your hands up. Let's start over here. Your name? Destiny Huber, and your attorney's name? Thank you. We've broken the docket down until from 9 to 10 to 10:30 to kind of give us more availability in the courtroom. So Mr. Murleader will be here at that time, about 10:30. Okay, so don't worry about that. Yes, ma'am. Thank you, Ms. Dean. Yes, sir. All right, thank you, Mr. Zanella. All right, anyone else name that I've not called that's present in the courtroom? All right, Mr. Schmidt, if you'll approach. All right, counsel, do we have anyone that's ready? Mr. Schmidt, are you ready? Court calls CR 14-272, State versus Johnny Wayne Brown. I believe we're set for docket call here today. Mr. Schmidt, are you ready?
Yes, Judge, we're ready. We've attempted negotiations with the state. The issue that we had was a unsuccessful discharge from PTI based on restitution payments. Mr. Brown's unable to make those restitution payments due to his health conditions and due to the COVID situation. So at this point, we're kind of put in a position where we have no choice but to ask the court for a trial.
And State, are you here, Mr. Schmidt? Okay.
Barely, Your Honor.
All right, let me make an adjustment. Can you hear me okay?
Yes, but now we're getting some feedback.
All right, Mr. Schmidt, that Mr. Brown is requesting a trial at this point. And so, Mr. Schmidt, you and Mr. Brown have attempted and feel like you have extinguished all possibilities of a resolution in this case.
Judge, I think so. I think at the end of the day, Mr. Brown was anxious to pay off the restitution and have this matter behind him. That's what he wanted to do. But we've kept resetting it for a docket call. Obviously, if the court would indulge us with additional docket calls, and the state has no objection, perhaps once the Wuhan or the COVID lightens up, we may be able to meet the demand of the state. But at this point, we cannot. And so because we cannot, absent continuous resetting, we have no other alternative but to seek a trial.
All right, State, are you able to hear Mr. Schmidt better now?
Yes, sir, we can hear him better now. Well, I guess if Mr. Schmidt thinks some more time will lead to a resolution in this case without the necessity of trial, that's fine with the state. However, since this is an unsuccessful discharge with PTI, there should be a jury waiver on file, in which case this would just be a trial before the court, which we should be able to do sooner rather than later. So if Mr. Schmidt does want more time, we would ask for a minimal amount of it.
Well, at the end of the day, Mr. Brown would like additional time. He came here today with the expectations that he would not be granted that time. However, I'm aware that it's I have to go back. I did not represent him on the PTI, so we go back and review the waivers and the validity of those waivers and do whatever is necessary after that. But if the state's in agreement, then we would ask that this matter be reset for a docket call at this time to see if Mr. Brown can come up with the restitution.
What's the estimate on restitution?
Judge, my estimate based on the paperwork is roughly about $2,300.
All right, so what the court will do is the court will reset for an additional docket call, and then that will be the final docket call. And we'll at that time discuss the trial before the court if there is in fact a waiver of jury trial. We'll set this for an additional docket call. I'm going to set it 60 days out. Is there an objection from the state for 60 days?
No objection, Your Honor.
All right, we'll set this for a final docket call on October 13th. A little more than 60 days. And the court will remain optimistic that Mr. Brown will be able to pay off all of his restitution or a significant portion of it. Obviously, if Mr. Brown's able to make a significant contribution towards his restitution, then the court would also consider an additional docket call to allow him to finish his obligations. If not, then on October 13th, we will discuss it possibly.
Thank you, Judge.
Anything further on Mr. Brown's case?
Mr. Brown.
And Mr. Brown, did you hear everything that the court and the state and Mr. Schmidt said?
I did, but I mean, there's some of it I couldn't hear, but what I heard is gonna reset it for October 13th. Then I have a final docket call. On that final docket call, is that gonna be whether I go to trial or do I have the October 13th to get my rest of the restitution?
Mr. Brown, this is Richard Schmidt. I will contact you after court and discuss what we have, okay?
Oh, okay. Thank you, sir.
All right, thank you, Mr. Brown. Have a good day.
Thank you.
We'll work on that.
All right, council, do we have anyone else that's ready? Mr. Hughes? Yes, CR 20-26, Robert Paul King. If you go ahead and have step up to the podium here.
Lord, we have filed a motion to substitute. The court took it under advisement pending Mr. Kane repaying the county for the court. He this.
Yes. State, can you hear Mr. Hughes?
Yes, sir.
Just let me know. Make sure that. Oh, hang on. This is okay. This is an affidavit of non-prosecution.
One second. He has a copy of the receipt.
And the court is reviewing the receipt from the Van Zandt County Community Supervision and Corrections Department, which indicates that Mr. Robert Paul King has paid all of the attorney fees.
Yes,
And Ms. Burns, let me ask, just so I make sure I'm reading it. Does that mean I get it credit?
World War II movie did? I thought it was more Civil War. Or was it Civil War? Okay.
I knew it was some war he was obsessed with. Okay.
Yeah.
Yeah, that was my first thought too.
Yes.
Perfect, thank you, appreciate it. And Mr. Hughes, do you remember what the court had indicated to Mr. Kane that he needed to pay?
Yes, Your Honor, asked us to repay the county as to the attorney fees, and he paid that.
I mean, was there a total that he was instructed to pay?
Yes, Your Honor, the amount is reflected there. We were not 100% sure, I believe, at that moment. The amount that was quoted was less than that initially. But County Council went back and checked his hourly rate when he billed the county, and the amount reflected there is the amount that appointed counsel was paid.
All right, then the court is going to grant the motion to substitute counsel. Court will sign that today, Mr. Hughes. And do we file any contested pretrial motions?
Not at this point, Your Honor, I don't believe. We are negotiating with the state at this point. They have been furnished with some documentation from the complaining witness. And if we could have one more docket call setting, I believe the matter may be resolved. Way short of a trial.
Since you were, since the court granted your substitution, the court's going to set this for an additional pretrial. That way, if you deem that there's important contested pretrial matters that the court needs to take up prior to trial, I'll allow that. The court's going to set Mr. Kane for a pretrial on September 15th, with all contested pretrial matters raised no later than 7 days before that date.
Yes, Your Honor.
I'm going to give this back to you, Mr. Hughes. You have him sign that.
Yes, signed.
Oh, he has signed it. Okay, then we'll stick to the paper.
Oh, okay, cool. Yes, sir.
All right, Mr. Kane, once you get your notice of it, then you'll be free to go, and we'll see you back on September 15th.
Thank you.
Did you in law school, Chris? Jacksonville? Second.
All right. Ms. Beasley, you have some pleas, is that right?
Yes, Your
All
Honor.
right.
I have two that are ready.
Okay, I'll get to those in just a moment. And Mr. Head, you ready?
Yes, Your Honor, we have pre-trial on
Mr. Tubbs, if you'll come to the podium. I'm sorry, I didn't see you earlier.
that's okay, Your Honor.
You were still sleeping correctly. This is CR 20-37, State versus Joe Everett Tubbs. We're set for pretrial. Do we have any contested pretrial motions?
Your Honor, we do not. We've received discovery. We did file the motion to amend bond. It's our understanding the court deleted the restriction on the firearms. Mr. Tubbs signed the other restrictions. We still have that motion. We understand the court's ruled on it. We just more or less would lodge our objection to the other restrictions. But we understand the court's already made that ruling.
Well, my recollection was that there was only one objection, and that was to the condition prohibiting possession of a firearm, right?
The one other issue was this offense does not involve any sort of drugs or alcohol. There's a restriction that he not drink alcohol, which otherwise would be legal, and that he be required to drug test, and he's concerned about the cost of that. He doesn't have much in the way of funds in his use. What he does have to hire an attorney and just doesn't want to be hit with additional cost. So that was really our only other issue, was the drug or alcohol testing and the cost, potential cost associated with that.
I believe that the cost on that is still at $15, Ms. Burns.
It's 10 for
10.
in-house.
All right, so it's $10 if he's drug tested. So
Yes,
the
sir.
court's going to deny the request to lift any drug testing or waive the cost thereof. However, the court will grant the motion in regards to possession of the firearm.
Thank you, Your Honor.
The court will sign those amended conditions, and I believe that you already have those.
Carl said he was, are you retained?
I am retained, and Mr. Tubbs did sign those, went over those with Mr. Waddell on the back.
Okay, great. We'll make sure that Mr. Tubbs gets a copy of these today before we leave.
Does he need to meet with Mr. Waddell before he leaves?
Back here and I'll get him a copy and we bring them.
Yes, because he's going to have to sign this amended. So I'm not sure what he signed before.
It still had the court appointed attorney on there.
Oh,
So I
okay.
took it off.
Take that off, so he needs to re-sign. Yes, ma'am.
All right, and you said no contested free trials this time, right?
That's correct, Your Honor. We have received discovery, and we're conferring with the district attorney's office regarding the case.
Okay, then the court will set this for a docket call. Are you available on September 15th?
Yes, sir, Your Honor.
Okay, then we'll set Mr. Tubbs then for a docket call on September 15th. And once he signs his conditions of pretrial release and that notice of appearance, then we're free to go.
Yes, sir. Thank you.
I'm looking for a reset.
Yes,
They're
ma'am.
really fast. I'll move those.
I'm sorry. Your Honor, may Mr. Tubbs step around
Yes,
back here?
yes,
Is that
please.
okay?
All right, Ms. Thompson, is Mr. Booker the only client you have on the 9 o'clock docket? I understand that you have Mr. Ellis at 1:30, I believe. Is that right? Is that all you have?
Yes. Yes, sir. The only one I have for this morning is Christopher Booker.
Okay. All right, then, is Mr. Booker here? Christopher Glenn Booker? I'll call his name. He's not present. So if you want to be excused till 1:30.
Thank you, Your Honor. See you this afternoon.
Thank you, ma'am. Is Mr. Stevens here? He was supposed to appear online. I did not see Mr. Stevens online. His client, Mr. Baines, is online. Mr. Baines, please hear the board. Mr. Baines, can you hear me? All right, we'll try Mr. Baines again later. Ms. Beasley, are you ready?
Yes, Your Honor, we're ready on Mr. Lane, Kristen Lane.
All right, Mr. Lane, come on up to the podium.
I believe he's in the hallway, Judge.
I just approached briefly. I apologize. It's been a while since I've been in your court. I'm not sure the exact procedure on those.
All right, you signed, he signed, I've got our date. Give you the middle two.
Right.
First.
Thank you, Judge.
Thank you, Judge.
Yes, please.
He's sent that last of the code.
Ms. Heisel?
Yes, Your Honor.
I see some, I guess, 5 motions to dismiss. There's nothing checked off as to the reason. However, I do see that it does say in the interest of justice. Is that what you want the court to dismiss on the grounds of?
Yes, Your Honor.
Those are supposed to be outright.
Why? All right, court calls CR 20-14, CR 18-435, CR 18-368, CR 18-436, State versus Tristan Craig Lane. Mr. Lane, if you will, if you'll raise your right hand, I'm going to place you under oath. Mr. Lane, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, make sure you speak up as loud as you can. Okay.
Yes, Your Honor.
Great, perfect. Thank you. You put your hand down. All right, you are Tristan Craig Lane, correct?
Yes.
And Mr. Lane, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yeah, yes.
And have you ever been diagnosed with any type of mental?
No.
In this case, you're represented by your attorney, Ms. Deborah Beasley. Are you pleased with Ms. Beasley's representation of you?
Yes, Your Honor.
Do you feel like you've had sufficient time to discuss your case with her and have all of your legal questions answered?
Yes, Your Honor.
You understand everything that you've read and signed today?
Yes, Your Honor.
And Ms. Beasley, do you believe that Mr. Lane is competent today?
Most definitely, Your Honor.
And you have, in fact, explained his legal and constitutional rights to him, and do you believe that he understands and appreciates the nature and consequences of any plea before the court?
Yes, Your Honor.
All right, Mr. Lane, in CR 20-14, you are charged by indictment with the third-degree felony offense of tampering with a governmental record with intent to defraud or harm. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice, and also carries with it a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, Your Honor.
Any sentence handed down by the court or jury must fit within that range of punishment. And it's my understanding that there's a plea agreement in this case, and that agreement between you and the state is that in exchange for your plea of guilt, the state's going to recommend that your punishment be assessed at 2 years confinement in the Texas Department of Criminal Justice, and that the court assesses a $1,200 fine, and you will be given 3 days credit for time that you have spent in jail on this case. Is that your understanding of the plea agreement? All right, then Mr. Lane, as to the third-degree felony offense of tampering with a governmental record with intent to defraud or harm that occurred on February 16th, 2018, how do you plead?
Guilty.
And Mr. Lane, are you pleading guilty because in fact you are guilty and for no other reason? Has anyone threatened you, forced you, or made you plead guilty to the offense?
No.
And Mr. Lane, I can't help but notice every time I ask you a question, you have to look to Ms. Beasley for an answer. Do you not understand my questions? Okay, so you're telling me, Mr. Lane, that you're guilty of this offense and no one's making you plead guilty to it.
No, Your Honor.
Now, now you're looking over your left shoulder to some young lady. Hang on. I need you to listen. This is very important because if we can't get through this, we're not going to do a plea today. And we'll just set it for trial and we'll go forward. Okay? I'm asking you, I'm not asking the young lady to your left. I'm not asking Ms. Beasley right now. I've asked Ms. Beasley if you're competent. She tells me you are. That means you understand what's going on. All right? I've asked you if this is the plea agreement, if you understand that. You said that you have. So at this time, I need to know, without you looking to Ms. Beasley, without you looking to this young lady to your left, I understand that these are important people in your life. But I think you probably have already had these conversations before you walked in this courtroom. Did you know what was going to happen when you stepped up to this podium?
Yes, Your Honor.
Okay, so I'm asking you, Mr. Lane, you and you alone, are you guilty of tampering with a governmental record on February 16th, 2018? Are you guilty of that offense?
Yes, Your Honor.
Okay, and no one's forced you, made you, otherwise convinced you that you had to do this against your will. Is that right? You're doing this of your own free will.
Your Honor, I don't honestly feel like lying to you today. I don't feel like that charge deserves 2 years. I don't think, no, Your Honor, I don't think I'm guilty of that.
Okay, so,
I don't think I'm guilty of that.
okay, so let's.
The only reason I'm taking that is because I'm scared of others.
All right, so when I ask you, are you guilty of this offense, you're telling me that you're not guilty of it. Now, there's a difference between thinking, there's a difference between what you feel is appropriate for that charge and whether or not you committed that charge. You can have committed that charge and feel like 2 years is too much, and both can be true, right? But I need to know, are you guilty of committing the criminal offense, the third-degree criminal offense of tampering with a governmental record?
Yes, Your Honor.
Okay, so you are guilty of that.
Yes, Your Honor.
All right. So let's do this out of abundance of caution, Ms. Beasley. I'm going to recall the case in a few minutes. I want you to go back and speak with Mr. Lane, and I want to make sure that when we proceed, that he has a very clear understanding. And I want him to have his advice of counsel before we go forward in discussing whether or not the court should take this plea agreement. Okay. All right. So go ahead and have a seat, Mr. Lane, and I'll call your case again in a moment. If you want to sit out in the hallway, that's fine. And we're going to move on to another case, and I'll recall your case. All right, Ms. Beasley, are you ready on your next client?
I'm ready on Mr. Huggins.
Okay.
Your Honor.
Mr. Huggins, if you'll come up to the podium, sir. CR 20-124. And Mr. Huggins is set for arraignment today. Have you had an opportunity to review the indictment with Mr. Huggins?
I have, Your Honor.
Are you prepared to go forward with arraignment?
I am, Judge.
Does Mr. Huggins waive the formal reading of the indictment at this time?
He does, Your Honor.
Is his name spelled correctly?
Yes, sir.
And does he understand the nature of the and range of punishment of the charge that's been brought against him?
He does, Your Honor. He wishes to ask for additional pretrial setting. We were actually intending, for the court's information, we were intending to do a plea today. However, my client is wishing to attend a drug rehab program, and I want to get that set up before we enter our plea. So we're hoping by the next court setting to have that done.
Okay. So he enters a formal plea of not guilty into the
At
record?
this time, Your Honor.
All right, then court will enter Mr. Huggins' plea of not guilty into the record, and we will set this for pre-trial on September 15th. Do you have any scheduling issues that day? Please.
We'll check, Judge. You said the 15th, Judge?
Yes, ma'am.
That will be fine, Judge.
All right. Then Mr. Huggins, you're ordered to reappear on September 15th, and once you get your notice of appearance, once you sign that and the copies left with the court, you'll be free to go.
I mean, since you got the medicine, okay? And then, Your Honor, I believe we are ready. I just need to get my client, Mr. Allen.
Okay. Is that a plea today?
Yes, sir.
Yeah, I can't call your case until she comes back, yes.
We need to ask how to do something.
Okay.
Case with Emmett Hernandez that's being dismissed. We paid the restitution, and I have the restitution, and no one really knows where I do pay.
Is it a probation plea?
It's not a probation, it's just a pending case.
Then it would be at the DA's office.
Okay.
You could send him over to the DA's office and then pay the restitution payment.
I'm doing it for him, he's not doing it.
You're not doing it. It would be in exchange for dismissal, not a.
Yes, it was a debt by check.
Step by check. We'll definitely do step by check and that's make reference to the DA's office. So if you want to go over there, and make that payment.
Okay.
And then bring your receipt back, if that's what you have worked out with the state.
Okay, because I, one other case, I'm just gonna be asking for one of the last resets.
Okay. We do miss Beasley here, and then
You mean they can go over to the DA's office?
yeah, if you'll go ahead and do that, take care of that, and then you come back, you'll be good to go.
Your Honor, may I approach and give you this and just tell him to go ahead and come out of his payment?
All right, we ready, Ms. Beasley?
Yes, Your Honor.
We ready, Mr. Allen? Yes, sir. All right. Mr. Allen, if you would, raise your right hand for me, sir. I'm going to place you under oath. Mr. Allen, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, sir, you are Ricky Lynn Allen Jr., is that correct?
Yes, sir.
And Mr. Allen, are you a United States citizen?
Yes, sir.
And do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Deborah Beasley. Are you pleased with her representation of you?
Yes, sir.
I feel like you've had sufficient time to discuss your case with her, have all of your legal questions answered.
Yes, sir.
Is there anything that you have reviewed and signed today that you do not understand?
No, sir.
Ms. Beasley, do you believe Mr. Allen to be competent today?
Most definitely, Your Honor.
And you explained to him his legal and constitutional rights?
I have, Your Honor, on every issue applying to this case.
And you also believe that he understands the nature and consequences of his plea.
Most definitely, Your Honor.
All right, Mr. Allen, you were indicted by the grand jury with the second-degree offense of sexual assault of a child. However, it appears to the court that you are wanting the court to approve a plea bargain between you and the state, wherein you will plead guilty to a lesser included offense, a third-degree felony of indecency with a child by exposure. And the plea bargain before the court is that you will be pleading guilty to that lesser included offense for the state's recommendation of punishment at 5 years confinement in the Texas Department of Criminal Justice and a fine of $2,000 in addition to court costs and 21 days credit for time that you have spent in jail on this case. Is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Ms. Beasley?
Yes, Your Honor.
All right. Mr. Allen, then to the lesser included third-degree felony offense of indecency with a child by exposure, how do you plead? Guilty or not guilty?
Guilty.
And Mr. Allen, are you pleading guilty because in fact you are guilty of that offense and for no other reason? And has anyone threatened you, forced you, otherwise made you plead guilty to something that you're not guilty of?
No.
All right, the court will accept Mr. Allen's plea of guilt to the lesser included charge of indecency with a child by exposure. Ms. Beasley, is there any objection to the admission of stage one, the stipulation of evidence?
No, Your Honor.
All right, court admits state's exhibit one, stipulation of evidence, takes judicial notice of Mr. Allen's judicial confession. Is there anything further from the state, perhaps any victim impact statement?
No, Your Honor, we have no victim impact statement to offer to the court.
Has the state been in compliance with its victim notification?
We have, Your Honor. It was sent on March the 4th of last year.
All right, is there anything further from the defense?
No, Your Honor.
All right, based on the court's review of the evidence, the court will follow the plea agreement and the recommendation from the state in this case. Court finding that there is sufficient evidence to convict Mr. Allen of this offense. Court hereby convicts him of the third-degree felony offense of indecency with a child by exposure. Court assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institution Division. Court assesses a $2,000 fine, $290 court cost. Court awards Mr. Allen 21 days credit for the time that he has spent in jail on this cause. Ms. Beasley, do you know a copy of Chapter 62 has been provided? Mr. Allen?
It has, Your Honor. He gave it to his family, but it was given to him by me in court this morning.
All right, thank you, Ms. Beasley. All right, Mr. Allen, you are hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over here with my bailiff to be fingerprinted. Bring the bailiff here to take Mr. Allen. It's going to be up to the bailiff. Yes, you may.
May I be excused for a couple minutes?
Yes, yes, thank you, Ms. Beasley. All right, Mr. Stevens, are you ready?
Yes, sir, we're ready.
All right, this is CR 19-298, State versus Austin William Banks. Record will reflect that both Ms. Stevens, Mr. Stevens, and Mr. Banks are both appearing online via Zoom. And I believe that we were set today for a plea. Is that correct, Mr. Stevens?
That's correct, Your Honor. I've received the plea paperwork. However, Mr. Banks had notified me that several members of his family have recently tested positive for the coronavirus. Although he has not been tested, out of abundance of caution, we were not able to sit down together and sign all the plea papers. And it was also my understanding that he would need to be present in court when we do a plea so that he can do the thumbprint and things of that nature. So we're asking for a short reset just so we can make sure we can get out of that 2-week window and just for the safety of all parties involved.
Objection, Ms. State?
No, Your Honor.
All right. Available on September 15th, Mr. Stevens.
I may not have heard that last comment. Was that a reset date?
Yeah, are you available on September 15th?
Yes, sir, I am.
Okay. All right. Then the court will grant the request for continuance, and the court will set Mr. Banks for plea on Tuesday, September 15th at 9 a.m.
Thank you, Your Honor.
All right. Thank you, Mr. Stevens.
May I be excused?
Yes, you may. Mr. Banks, this will be the only notice that you get. All right. All right, Mr. Banks, you're muted. Mr. Banks, just stay in contact with your attorney, Mr. Stevens. Thank you, Mr. Stevens. Thank you, Mr. Banks.
Okay. Can you?
White, what do we do with Mr. Mackey? Yes. That's something we can do in less than 5 minutes.
Oh, yeah.
Okay. All right, Mr. Mackey, you'll come up to the podium, sir. I've got an interpreter scheduled for 10 o'clock this week. All right, this is CR 20-32, State versus Montrell, DeAndre Mackey. I believe that we're set for Docket today. Is that correct?
Well, that's correct, Your Honor. I had an opportunity to talk with the state's attorneys on this, and we have come up with an agreement in principle. We don't have the exact numbers, looking to reduce this down to a state jail felony and punish it as a Class A misdemeanor. Once we do get, it will involve a jail sentence. So Mr. Mackey will, once we find out how many days exactly we're going to be offered, Mr. Mackey will need some time to be able to get everything together. And I believe Mr. Cox will confirm what I said.
Oh, has he already signed it?
Yes.
All right, any objection from the state on Mr. White's request for additional time?
No, Your Honor. Mr. White, he pretty much summed up our agreement. We're 98% of the way there. Just a couple details that need to be hammered out, but the court would give us a reset date. We can probably have it resolved whenever that date is.
Okay. All right. Court will set for final docket call on September 15th.
I have a lot of things on September 15th. That'd be good, Judge.
So, Mr. Mackey, you're ordered to reappear on September 15th for your final docket call. Once you get a copy of this notice of appearance from Mr. White, then you'll be free to go.
And that's 9?
Yes, 9 a.m.
Okay.
Yeah, if you want to let him know that I'll pull him in a moment, but I think it's in this interpreter. All right, and where is Mr. White? Where is Mr.
I gave him
I have a Spanish interpreter scheduled for 10:30 or 10 o'clock, so I'll pick that up. Right, well, I don't see, they're not online. Mr. Morales is, but I don't see Mr. Jackson. And Paul's talking on this. All right, Mr. Adams, do you have anything that's quick?
I do.
Okay. CR 20-A3, State versus Jacob David Howell. Mr. Howell, please come to the podium, sir. All right, we are set for pre-trial today, Mr. Adams, is that correct?
That's correct, Your Honor. However, I'm going to ask the court if we could reset this for another pre-trial hearing at a later date. I don't think I have a complete set of the discovery from the state yet.
You know what we're lacking?
I think there may be some audio visual that I don't have. Typically here, that gets provided to defense in CD format, and I don't think I have one with Mr. Howell's name on it yet.
Right. And State, if you will determine whether or not there's audio visual evidence available for Mr. Howell and make sure that that's already been provided or notice been sent to Mr. Adams, accomplish that. Court will reset Mr. Howell then for pre-trial on September 15th. Do you have any scheduling issues that day, Mr. Adams?
I don't think so, but quickly find out. No, Your Honor.
All right, then we'll see Mr. Howell back on September 15th at Donnie. Mr. Jackson, are you ready on your client, Mr. Client here?
Yes, Judge.
Okay, is he set up? We have him set up?
He's in the jury room.
Okay,
And what I took the plea for.
you just give it to the panel there. Good morning, Mr. Cross. How are you?
Good morning, Judge. How are you?
Good. How you doing, sir?
Good. All right.
Just a moment. We're gonna get set up.
Let me test something. Can everyone still hear me? No.
All right, once we get Mr. Lorenzo set up for the interpretation, we'll begin. Mr. Perales, I believe that I've got you set up correctly on my end. I think it's just on the user end.
Mr. Perales?
Shut that door, please. Yes.
Okay.
Two.
All right, so Mr. Lorenzo is able to hear you, hear and understand you? Yes, sir. If you'll just come right up here to this little blue area, that way I can get you on camera and we can pick you up on the mic.
Judge, I'm sorry, we're almost getting it worked out. It's too close to have the microphone on here, so she's taking it down to my office.
I think that's okay as long as that door stays closed.
I don't know, when we closed the door, it was still, I could hear it.
Okay.
I thought, we're almost there.
Want me to have a seat?
No, that's fine. That's fine. She just walked down the hallway. We'll have you here, that way you can see yourself, that way he can see you. And that's our microphone right there.
All the technology.
It's supposed to help us. Slow this down.
Yeah.
It's too low the volume.
Mr. Leonardo, can you hear us? Okay, speak and see if you.
Sí. Sí. Gracias.
I believe we're ready to go. All right, paper calls CR 20-30, State versus Antonio Lorenzo. I'm sorry. Yeah.
Sí.
Lorenzo.
It's the way they have it written, it's backwards. It's Lorenzo's the first name.
Lorenzo's
Chan Bernal is the last name.
What's the last name?
It's Bernal, but with the Latin countries, they do the mother and father's name, so it's Chan Bernal. CHAN.
All right, I'm probably gonna call him Mr. Lorenzo because that's how it's showing up in the judgment.
Sure.
All right, Mr. Fowlis, let's go ahead and have you identify yourself for the record, and then I'll place you under oath. All right, Mr. Fowlis, if you'll raise your right hand, repeat after me. Sir, do you swear that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial, to the best of your skill and judgment, so help you God? Thank you, Mr. Brown. All right, you are Antonio Chan Bernal Lorenzo, is that correct?
Sí.
And Mr. Lorenzo, I know that may not be the name that you go by, but that's the name that appears in all the legal documents. So I would ask for your forgiveness on that if you actually go by Mr. Bernal, but I'm going to call you Mr. Lorenzo. Is that okay?
Okay.
All right, and Mr. Lorenzo, are you a United States citizen?
No.
And you understand that a plea of guilty or no contest in today's proceeding may have implications regarding your legal status within this country?
Sí.
And so you're willing to, you're wanting the court to move forward with the plea agreement in this case, despite the fact that it could have consequences regarding your status in the country?
Sí.
Okay. And do you read, write, and speak English?
No.
Have you used the assistance of a foreign language interpreter to review the legal paperwork that bears your signature here today?
Sí.
All right, in this case, you are represented by your attorney, Mr. Jackson. Are you pleased with his representation of you?
Sí.
You feel like you've had sufficient time to review the case with him and have all of your legal questions answered? Sí. And Mr. Jackson, do you believe, Mr. Jackson, do you believe, Mr. Jackson, do you believe that your client is competent today?
I do, Your Honor.
And do you believe he understands and appreciates the consequences of his plea before court?
I believe he does, Judge.
You've explained to him all of his legal and constitutional rights?
I have.
All right, my understanding of the plea agreement is that Mr. Lorenzo Bernal is going to be pleading guilty to the second-degree felony offense of unlawful interference or use of a wire or oral electronic communication device, a second-degree felony, in exchange for a recommendation from the state that the court defer a finding of guilt and place Mr. Lorenzo on 3 years community supervision, and that he receive a $4,500 fine. And the state's going to be recommending to the court to dismiss 2 unfiled, unindicted charges, one engaging in organized criminal activity and the other in unlawful use of a criminal instrument. In addition, there will be court costs of $290 and reimbursement fees of $35. Is that your understanding of the plea agreement, Mr. Jackson?
It is, except my understanding is that it'd be 3 years deferred probation.
What did I say?
You just said 3 years.
I said 3 years. Okay, that's my mistake. 3. The recommendation is deferred. Finding of guilty deferred, and he be placed on 3 years community supervision.
That is my understanding.
All right, thank you, Mr. Jackson. Mr. Lorenzo, is that your understanding of the plea agreement as well?
Sí.
All right, then, Mr. Lorenzo, I need to explain to you the range of punishment for this type of charge. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years nor more than 20 years confinement in the Texas Department of Criminal Justice Constitutional Division, and also carries an optional fine not to exceed $10,000. Do you understand that range of punishment?
Sí.
That means, Mr. Lorenzo, that if the court approves this agreement and places you on community supervision, if you subsequently violate that community supervision, the court could assess your punishment upon a finding of a violation anywhere within that range of punishment from 2 years all the way up to 20 years and a fine not to exceed $10,000. Do you understand that?
Sí.
Okay, then Mr. Lorenzo, to the second-degree felony offense of unlawful interference, use of a wire or oral electronic communication, how do you plead? Guilty or not guilty?
No culpable.
And Mr. Jackson, is that your understanding? Is that Mr. Lorenzo will be pleading not guilty to that charge?
No, he may not understand exactly, but I would proffer to the court that Mr. Lorenzo has understand his rights in this case, his rights to have his witnesses, a right to confront the state's witnesses. He's freely and voluntarily given up those rights, and he wishes to enter a plea of guilty before the court.
Mr. Lorenzo.
What is that?
It's Senor Lorenzo. Mr. Lorenzo, the court asks you if you are guilty or not guilty of this offense, and you have indicated that you are not guilty of this offense.
Sí.
Understand the difference? Guilty?
No entendí.
And what did you not understand?
Que sí soy culpable. Con la palabra que no entendí eso. Yo estoy de acuerdo con eso.
So I'm just going to ask you again. So are you guilty of committing this offense, meaning that you did commit this offense?
Sí.
Okay. All right. Then with that explanation to the court will accept Mr. Lorenzo's plea of guilty before the court. Mr. Jackson, is there any objection to the admission of States 1, the stipulation of evidence in this cause?
No objection, Judge.
All right, court admits States Exhibit 1, the stipulation of evidence in this case. And I see here that his signature is not been sworn. So, Mr. Lorenzo, I need to ask you, I'm gonna hold a document up to the camera. Is this your signature here on this document?
That's my signature. Go up.
Sorry.
Yeah, there we go.
Is that your signature?
Sí.
Okay. And by signing this document, are you telling me that you have read it with the assistance of a translator and that you understand everything contained in this document?
Sí.
All right, the court hereby accepts Mr. Lorenzo's plea of guilt. Takes judicial notice of Mr. Lorenzo's judicial confession. Is there anything further from the state? Sorry, state, I had to mute you. There was some noise.
She's still muted.
Nothing further, Your Honor.
Okay. Anything further from the state?
Nothing further.
Pero yo te dije lo que él me dijo. Yo voy a hablar con él.
Okay.
All right, upon reviewing the evidence, the court will find that there is sufficient evidence to convict Mr. Lorenzo of this offense. However, the court will follow the plea agreement in this case. The court hereby defers a finding of guilt. Court places Mr. Lorenzo on 3 years community supervision. Court assesses a $4,500 fine. And the court dismisses under section 1245 of the Texas Penal Code, F-19-790, engaging in organized criminal activity, and also F-19-781, unlawful use of a criminal instrument. Court assesses $290 court costs. Court orders Mr. Lorenzo to reimburse St. County $35 in fees. Mr. Jackson, have you reviewed the conditions of community supervision with your client?
I have, Your Honor.
All right, you believe that he understands everything that's expected and required of him?
I believe so.
All right, Mr. Lorenzo, you've gone over your conditions of community supervision, and you understand that everything that is expected and required of you?
Sí.
And you understand that if you violate your community supervision, the state could file a motion to bring you back before the court. And if the state proves to the court that you violated your community supervision, you understand that the court could revoke your community supervision and assess your punishment anywhere within that range of punishment from 2 years to 20 years. You understand that?
Sí.
All right, Mr. Lorenzo, you are hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you return to the courtroom here to be fingerprinted by the bailiff, after which you are to report to the probation department. And Ms. Taberham, if you will just bring the iPad with Mr. Lorenzo.
Judge, will they go over his conditions again?
The probation department will, but if he needs the assistance of an interpreter, I'm sure that'll have to be set up for a later date. Is that right?
Well, he has his wife with him who speaks both languages.
Okay. All right, Mr. Lorenzo, if you'll come back into the courtroom for fingerprinting, please.
Very excuse, Judge.
Yes, thank you, Mr. Jackson.
Bobby.
Thank you, Mr. Appreciate your patience, sir. Todd, are you ready? Are you ready on Emma Hernandez or Cruz Martinez?
Both. The restitution has been taken care of, and they said to tell you they'd be submitting a dismissal today on Mr. Hernandez. And then they also said that they're okay. I just take one more, what you said, from the teams.
Go ahead and step back. You can use that to sign. I'll make sure that you hear. 19, 2, 3, 4. So, State, Mr. Hyde has indicated that you're going to file a motion to dismiss the case, CR 19, 2, 3, 4, State versus Emma Hernandez.
That's correct, Your Honor. Mr. Hyde appeared at our office earlier this morning. He presented us with the check for the full amount of restitution. Our agreement was the restitution was paid up front. We would dismiss the case. So later today, I'll be presenting the court with the motion to dismiss.
All right, then the court will sign that order to dismiss when it's presented to the court. CR 19-181, CR 20-54, State versus Cruz Martinez. And Mr. Hyde, while Mr. Martinez is signing that notice of appearance, what's the update on whether or not Mr. Martinez has submitted the fees owed to the county for the pre-trial release appointment of midget counsel? I'm sorry, say that again. I can't hear.
He's made payments towards that, and he made one again today.
Okay, so he still hasn't satisfied the $400 that Ms.
Probably not completely.
All right, let's do that. Let's take a moment and let's go to pre-trial release and just check with them so that I'll know, because I don't know that I've granted your motion to substitute yet.
Okay.
I don't know that I have. I have to double check. So I'll recall it in just a moment. Go back here. Mr. Martinez, if you want to just have a seat, Mr. Hyde's going to meet with the, and you can just sit right there. That's fine. You don't have to go all the way to the back. So are you ready? Mr. Adams?
Yes, sir.
I'm ready. All right, Ms. St. Mary. Ms. St. Mary's going to go to custody of this.
Yes, sir.
All right, this is CR 10-442, State versus Michelle St. Mary. And Ms. St. Mary, if you will, raise your right hand for me now. I'm going to place you in oath. Ms. St. Mary, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, if you want to, you can put your purse down on that bag right there on that. There you go. All right, Ms. St. Mary. I'll pull up here. All right, Ms. St. Mary, you are currently on community supervision with this court, and the court placed you on community supervision on December 6th of 2012 for the offense of possession of marijuana, 4 ounces to 5 pounds. The court reviewed the evidence on that date, found that the evidence substantiated your guilt, but the court deferred a finding of guilt and placed you on community supervision for a period of 5 years. It was during that period of community supervision that the state filed a motion to adjudicate and revoke your community supervision. They filed that on November 1st, 2016. And in that motion, they alleged 3 various accounts of ways that they have alleged that you have violated your community supervision. Have you had an opportunity to review that motion with your attorney, Mr. Adams?
Yes, sir.
And Mr. Adams, is your client waive the formal reading of the state's motion to adjudicate at this time?
Yes, Your Honor, I'm aware of the reading.
And it appears that Ms. St. Mary and the state has reached an agreement wherein Ms. St. Mary will be pleading truth to all 3 counts in exchange for a recommendation that her sentence be set at 60 days confinement in the county jail, with her receiving credit for 36 days, ordered to pay the balance of her financial obligations, with her submitting herself to the jail today at the time of plea, serve out the remaining days. Is that your understanding, Mr. Adams?
Yes, Your Honor, that's correct.
Ms. St. Mary, is that your understanding of the plea agreement? And Mr. Adams, do you believe Ms. St. Mary to be competent today?
She's competent, Your Honor.
And was this originally prosecuted as a 1244A or B, or is that the recommendation today is to make that punishment under 1244A or B?
That's today's recommendation.
In what she originally, what was the original community supervision, the charge? Was it just a state jail felony?
Correct.
Judge, I couldn't hear Mr. Adams' response, but I think if I recall correctly, it was to be a 1244A.
Is that the agreement, 1244A? So Ms. St. Mary will receive a state jail felony conviction with the punishment being in the Van Zandt County Jail?
That's correct, Your Honor.
Got it. I got it that time, Judge.
Okay. All right, then this then actually counts 1, 2, and 3. Are those counts true or not true?
True, sir.
And Ms. St. Mary, are you pleading true to each one of those counts because in fact those counts are true and for no other reason?
They are true.
So no one's threatened you, forced you, pressured you to plead true to something that's not true. All right, the court will accept Ms. St. Mary's plea of true to each count as alleged. Mr. Adams, is there any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No objection, Your Honor.
All right, court admits State's Exhibit A into evidence and also takes judicial notice of Ms. St. Mary's judicial confession. Is there anything further from the state?
No, Your Honor. We'd rest to close.
Anything further from the defense?
Nothing further, Your Honor.
All right, then the court, upon receiving Ms. St. Mary's plea of true, finds that Ms. St. Mary has in fact violated the conditions of her community supervision. Court will follow the plea agreement in this case. Ms. St. Mary, court hereby adjudicates you of the state jail felony offense of possession of marijuana, 4 ounces to 5 pounds. The court assesses your punishment in accordance with Section 1244, subsection A. Punishment at, or revokes your community supervision and assesses your punishment at 60 days confinement in the Van Zandt County Jail. Court awards you 36 days for credit that you have spent in jail on this cause already. Court orders you to pay the balance of your financial obligations, and the court, upon the signing of the judgment, orders you into custody today.
Thanks, sir.
And Ms. St. Mary, I'm not sure that I asked you, but let me ask you at this time. Are you pleased with Mr. Adams' representation of you?
Yes, sir, I am very pleased. Thank
And you've had sufficient time to go over your
you. And
case?
also with the
Say that again, I'm sorry.
also with what I've been given from the state, I really appreciate it.
Okay, all right.
Just be back here.
State, did you hear Ms. St. Mary?
I did, Judge.
Thank you.
All right, Ms. St. Mary, hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step up here with the bailiff to be fingerprinted, and the bailiff here to take Ms. St. Mary to the custody.
These are my meds. Put them on the table. Okay. Okay. Yeah. Thank you. Thank you so much. Thank you.
Hey, you're on.
Hang on just a second, I got air traffic. What?
I think that's all I have on this morning's docket.
I believe that's correct. So we already handled Mr. Howell, right?
Right.
Okay. All right, so we'll see you this afternoon.
Right, is that here?
No, it'll be at the jail.
Okay.
It'll be at the jail.
Helps to show up at the right place.
Okay. It does help. All right, Mr. Howell.
He's
All right, who are we talking about?
Cruz Martinez on the motion to substitute.
All right, so he's paid the 486.
Yes.
Let me look in here to make sure that I've signed it. This is not working for us. All right. All right, Mr. Martinez. We are back on the record, CR 19-181, CR 25-4. If the court has not granted Mr. Hyde's motion to substitute, the court, based on Mr. Hyde's statement as an officer of the court, that Mr. Martinez has satisfied his financial obligations for the court-appointed attorney fees of Ms. Ann Thompson, the court will, if it has not already, grant the motion to substitute counsel and order Mr. E. Hyde as counsel for Mr. Martinez. Okay, Mr. Hyde, my docket says we're set for plea today, is that right?
We'd like one more announcement, Your Honor.
All right, state any objection, Mr. Hyde has requested a reset.
No, Your Honor.
No objection?
No objection.
All right, do we believe, if I said it one more time, do we feel like we're gonna be able to resolve it?
Yes.
So if I said it on September 15th?
It'll be fine.
All right, court will set Mr. Martinez in for plea. This will be the final setting for plea on September 15th. Mr. Hyde, you have a notice of appearance from Mr. Sierra Simon?
Yes.
You'll write that date in there, I guess. September 15th. And then you can get them a copy and leave the first and last here. All right, I'm gonna call the 10:30 docket. When I call your name, please say here, present. Annual Mallory here. Thank you, Ms. Meyer. Lindy Delaney? Lindy Delaney here? I know Mr. Merlier is in the hallway.
And Judge, Miss Delaney was in our office attempting to pay some restitution and had to go change her payment type. So I'm sure she's doing that, but I have seen Miss Delaney and Mr. Merlita this morning.
All right, thank you, Ms. Hyman. And then Destiny's here, Destiny Hubert. Lacey Tucker. Lacey, I believe, is appearing online. I don't see her yet. I see her logged in, so we'll show her to be here and maybe get a visual on her in a moment. Mr. Christopher Vanderlinden. All right, I got a docket note that says Mr. Vanderlinden is in the Tarrant County Jail. I'm sure we'll get more information on that. Mr. Merliger. Jay Bruner. Mr. Bruner here, Mr. Wood.
Judge, I did not see Mr. Bruner here. I was contacted by some individuals who care for Mr. Bruner, and I was expecting him to possibly not be here today based on some of the information that they told me. So I don't anticipate that he'll be showing up.
Okay. Is that all you have? Well, you have a few more.
Judge, I got Mr. Bruner and two more that I can make quick announcements on.
Okay. That's Kyle Connor. I believe Mr. Connor's in the state jail.
Mr. Connor's in state jail.
And then Mr. Faulkner is in the Hopkins County jail. All right, well, Mr. Wood, let's go ahead and take up then. Let's go ahead and take up Kyle Connor. This is CR 20-109, State versus Kyle Stephen Connor, set for arraignment today. And I do have a docket note that Mr. Connor is currently in the Lindsay State Jail Unit with a release date of October 28th. Is that correct?
That's my understanding, Your Honor, and I have been in contact with Mr. Cox on this case, trying to see if we can figure something out. I've not had a chance to talk to Mr. Connor, obviously being in state jail, but we're in the process of trying to figure something out on it as quickly as we can.
State, are you going to be requesting a bench warrant for Mr. Connor, or are you want the court to set it for a time after he's anticipated to be released?
Judge, since his release is forthcoming pretty soon, I wouldn't oppose a 60-day reset to give him time to get out.
Do you know if we have a hold on Mr. Connor or Mr. Wood? Do you know if there's a
I don't think there's a hold, Judge, but I can double check and let the court know. We've tried to put a hold on it, but I don't know if it's actually we succeeded in that.
Do we anticipate a bench warrant request before he is discharged from TDC?
I think, Judge, I can probably let the court coordinator know on that, or Mr. Cox and I can let the court coordinator know on that within probably the next couple of weeks.
All right, we'll set Mr. Connor then for arraignment on Tuesday, November 10th. That would be after his anticipated release date. Sure. Tuesday, November 10th. All right, CR 117, State versus Bobby Daniel Faulkner. As I said before, my docket indicates that Mr. Hawkins, or that Mr. Faulkner is in the Hopkins County Jail. Is that correct?
That is correct.
And do we know what he's being held on, how long he's being held?
Judge, I want to say Judge, I'm not entirely sure what the cases are. My understanding is there are, I believe, 2 additional felonies that we picked up in Hopkins County that we can currently held on, if I'm not mistaken.
Is there going to be a request for a bench warrant? Or what they ask you to do? State meeting?
Yes, Your Honor.
Is there a request for a bench warrant, or what's the state asking me to do on this case?
Judge, I think we're going to hold off on a bench warrant at this time. I got an email this morning from Mr. Wood. What he is requesting that we do, I need to consider. I'm leaning towards going in the direction he wants to go, but at this time, I need a little bit more time to think about it. But we are not requesting a bench warrant at this time.
The court will set September 15th and see where he's at. Other than Mr. Bruner, that's all you have, and you're indicating to the court, Mr. Bruner.
I don't anticipate he'll be here, Judge. If he is, I'll be around today in Canton. If he does show up, the court wants to give me a call. So we'll take that, but I don't anticipate he'll.
J. Michael Bruner.
Judge, I'm not sure what happened, but the court's microphone got substantially lower all of a sudden.
We haven't made any changes. Can you hear me now?
Barely, Judge. And we can't hear Mr. Wood either.
It's not a bad
Yeah, I don't know. It's the green light's on. It's on. We haven't changed anything from earlier.
Turn the volume up.
Mr. Mulder, are you ready on Mr. Wynn?
Yes, sir.
Yes, thank you. All right, Mr. Wynn, if you'll make your way to the podium. This is CR 14-109, State versus James Robert Wynn. And Mr. Mulder, what's your number on
Well, Judge, I have sent an email to Mr. Cox and CC'd the Dallas County Probation Department. Dallas County's position is they are willing to withdraw pending approval by the judge, but the probation is recommending that they withdraw their motion and continue Mr. Wynn on probation there. So if y'all are in agreement, then I think that's kind of where we stand. But I think I need to wait for Mr. Cox to decide what he wants to do.
Your Honor, I got that email about an hour ago, and again, just like the last case with Mr. Wood, I need some more time to consider Mr. Mulder's proposal and the proposal from the Dallas County Probation Department. I feel like I need to run that by our probation department as well.
Sure.
So I'm not quite ready to make a decision yet today, Your Honor, and would ask for a little bit more time to consider Mr. Mulder and the Dallas County Probation Department's proposal in this case. I won't need much time. I know we have a docket Thursday. I don't think I'll be ready by then, but whenever the next court date is after Thursday, if that works for Mr. Mulder, I should be ready to go by then.
All right, the only other concern has is that it's been reported to me that there's been some GPS violations that may include Mr. Wynn not charging his GPS device, having some issues with that. So what I'm going to do is I'm going to order Mr. Wynn to come back and speak with the pretrial release officer. And Mr. Mulder, I would ask that you speak with your client regarding this information that they give to the court. So that's, if he's not maintaining his GPS device, and that's a significant concern to the court. So what I'm going to do is I'm going to reset this for one last hearing, and either what I'm going to do is I'm going to set it for today being August 4th. I'm going to set it for the contested docket on October 1st. That should give the state has time to determine what they're going to do on Mr. Wynn. If not, then we'll go forward with a contested hearing on October 1st on the state.
Very good, Judge.
All right, so Mr. Wynn, we have a notice of setting that. Mr. Wynn, I'm going to give you a notice of appearance. Ask that you sign this. I'm going to give you a copy. They do that on October 1st. After that, I want you to report to the Pretrial Release Department so you can discuss the issues with your GPS advice.
And that's October 1st at 9 a.m., Judge?
Yes, sir. All right, Mr. Wynn, I'm gonna have you sign here where it says defendant, then you're gonna get a copy of that. And then after that, of course, the pretrial release department is good. All right, Mr. Mulder, anything else?
No, sir.
All right, we'll see you on October 1st unless there's a resolution.
Okay, very good. Thank you. May I be excused?
Just you ready to go back? Yes. Mr. Ashmore, are you ready on Ms. Dean?
I'm ready, Judge. Sorry.
All right, Ms. Dean, if you
Morning.
come up to the podium, please. This is CR 19-230, State versus Vivian Darlene Dean. And I believe we're set for docket call today, Mr. Ashmore.
We are, Your Honor. I have had some difficulty communicating effectively with my client. I have this morning filed a request for an examination of my client, and she's charged with a very serious offense, and I know that's not before the court today, but I just want the court to know two things. That motion has not been filed for delay, but I would ask that because Mr. Cox and the state of Texas and Ms. Hillary have not had a chance to review that the court please set us for what may be a contested motion docket, simply because I've had some concerns communicating with my client in the last 2 to 3 weeks that I feel compelled to bring this to the court, and so I apologize for bringing it late. I thought it was filed previously, but it hadn't been, but it is now on file. And I'm just going to ask the court to reset us to a motion docket.
Judge, if I could, obviously I can't speak to the competency of Ms. Dean because I haven't had the conversations with her like Mr. Ashmore has. However, having dealt with Mr. Ashmore on this case for the last few months, I'm confident that this motion is not being filed for delay. And I'm kind of not surprised that he's having communication issues with his client. So I trust when Mr. Ashmore says this is not for delay, that he's being truthful with the court.
Thank you.
All right, we'll Ms. Dean for docket call, and we'll set her for a hearing. We'll set her for a status on competency motion. That'll give me time to review the motion, and we'll take it up that day. Unless the court is satisfied by the motion as submitted and states an agreement that after you've had time to review it, if the state will let the court know. And we'll set this on August 25th.
Thank you, Judge.
Hey, Mr. Ashmore, while I've got you, on Ms. Dean's motion that you submitted, is that accompanied with an affidavit supporting that? Or is it just a motion? Does it contain the information that the court's going to need to make it, or is it just a request for an examination without merit?
Judge, it's a request, and I have some medical records that have been redacted and provided to the state. And it would be my request to provide those to you in camera for your review, which are supportive of my motion. And I may need to supplement it, but that was my initial thought, because there has been some vacillation back and forth between, mental disease is not a perfect science, and there have been what I interpreted as moments of clarity, but as this case has progressed, we're hitting roadblocks, Judge, and I'm concerned about the health and well-being of my client, and I'm trying to do my best to make sure I'm protective of her health, mental health.
I understand that. I don't want to argue the motion. I just want to know if when I review the motion, is it going to have evidence supporting the motion in the motion? Or is it just going to say you're requesting competency evaluation? My point is that if there's nothing in the motion to support it, the court's not going to grant it. There's an affidavit regarding incidences or the reason that you brought it, then the court will review that. I may be able to grant it without a hearing. I'm telling you, if there's nothing in the motion other than a request for competency evaluation and general statements, then the court, as policy, will not grant that.
And I understand that, Judge, and I'd request leave to amend that immediately, and I'll make sure that that's all there for your review with a declaration from myself, so you understand why I'm bringing it, Your Honor.
All right, that's what I want. The court will grant that. Okay. All right, Ms. Dean, once you get a copy of that appearance form, we'll see you back on August 25th in 2 weeks. Or 3 weeks at 9 o'clock. Yes.
Hold on, Diddy, you're not.
I don't know. I mean, microphone's set up on green. Mr. Ashmore, do you hear me okay?
It kind of fades in and out, Judge. It's also lawn day in the city of Rockwall, and I'm sorry that there's a buzzing in the background, so I'm trying to keep that on mute so I don't disturb the court's business.
All right, Mr. Ashmore, are you ready on Annual Mallory?
I am, Your Honor.
Okay, Miss Mallory is here. She's in her wheelchair and she's on the, as you would be looking, the left side of the courtroom. Miss Mallory, can you see Mr. Ashmore from where you're at? You need to come up. If you can't hear me, you need to come on up. Just bring her on up here, right here in front.
Do you think I should have an interpreter?
Let me try. Is that any better?
Yes, Your Honor. It comes and goes, but right now it's good.
Is that better?
Yes, Judge, that's working much better. I don't know.
I turned off. It was on the English channel, so it shouldn't have. All right, can you see Miss Mallory now?
I can.
Okay. All right. This is file number CR08-375, State versus Angel Gordon Mallory. This is the state's motion to revoke, I believe. Do we have any announcement, Mr. Ashmore?
I've had a conversation with Ms. Heisel in the state prosecutor's office, and it's our understanding that the state is going to dismiss this matter. And I don't mean to speak for the state, but that was my understanding.
I remember this.
Okay, you know.
And just briefly, Your Honor, this is a very lengthy probation period, which there were violations, but the violations were simply inability to pay. And we had made a request for some consideration for leniency because of financial restrictions, an elderly woman. And that was my understanding as to where we stood on this matter.
Dave, can you hear Mr. Ashmore? Can you hear the court?
Yes, Your Honor, and I thought that I had e-filed a motion to withdraw the state's motion to revoke in this case. I will double check on that because we're using my computer for the Zoom hearing. I can't check on that right now, but I will check on that, and if it's not been done, I will make sure that gets done today.
All right, so the state is withdrawing its motion to revoke in this case. Is it a motion to withdraw and continue, or a motion to withdraw and terminate?
Withdraw and terminate, Your Honor.
Okay, all right, then Ms. Mallory, based on Ms. Heisel's statement as an officer of the court, she's indicated that they're going to dismiss your case. So you're free to go. Have a good day.
Thank you, Judge.
All right, Mr. Ashmore, is that all you have on this morning's docket?
I believe it is. There, Mr. Devine was set, but there's a waiver of arraignment on file.
Yeah,
and again, I apologize for not being there in person, but thank you for that. I'm set for another Zoom trial, and it seems like this is our life right now. So thank you for the court's ability to let us do this way.
Yeah, you're welcome. Have a good day, man.
May I be excused? Thank you, Judge.
Mr. Murley, you ready? Who are you ready on?
Judge, Ms. Lacey Tucker should be waiting on Zoom. Her case is just a reset because we haven't received the video discovery yet.
Ms. Tucker, can you see and hear the court? I see that you're logged in, but you're muted.
I'm here. Okay.
All right, this is CR 20. Well, let's see. CR 20-92, State versus Lacey Linda Tucker. We're set for pretrial. Go ahead, Mr. Murley.
Judge, we received the online discovery from the portal. The DA's office is working to get the video discovery from law enforcement. And Ms. Abney is working to do that. She's asking for some more time so that we can get the discovery and review the case and then be set for pretrial.
All right, court will reset this for pretrial on September 15th. Do you have any scheduling issues that day?
I don't believe so. Let me check.
And so this is not an issue where we have the tape already or the DVD already at the DA's office. We're having to seek this from the law enforcement agency. Is that right?
That's correct, Your Honor. We're requesting additional footage, contacting the law enforcement agency to ascertain whether we have all the footage or whether there's additional video.
All right. It's on September 15th.
She's not reporting to us. I'm asking the court that she report to pretrial or intake for conditions of pretrial.
All right, Ms. Tucker, you are on conditions of pretrial release associated with your bail in this case. The pretrial release department has indicated that you need to, you have not reported to them and you need to sign your conditions of pretrial release. So you need to report to the pretrial release department here in Canton at 250 East Groves no later than 5 p.m. tomorrow.
Okay.
All right, so you'll need to appear over there and sign your pretrial release papers and meet with pretrial release officer Waddell. Okay?
Okay.
All right, so failure to do that could result in your bail being, your bond being revoked and you being placed back in jail. Do you understand that?
Yes, sir.
Okay. All right, other than that, this will be the only notice that you get that you're ordered to be back on September 15th at 9 a.m. for a pretrial hearing in this matter. Okay?
Yes, sir.
Thank you. You're free to go.
Thank you, Your Honor.
Are you ready on Mr. I'm sorry, Ms. Huber?
Yes, that'll be a plea, Your Honor, but Ms. Delaney is going to be another reset. We're going to take care of that first.
CR 20-9, State versus Lindy Marie Delaney.
Your Honor, we have received the discovery of the case, and we've received a plea offer from the state. However, we're still in plea negotiation. I've asked the state for a counteroffer after Ms. Delaney paid the restitution of this case to the DA's office this morning. We're just asking for additional time to continue the plea negotiation. We anticipate this case ending in a plea under a reduced offense or misdemeanor. And Ms. Delaney said that she is willing to accept probation and just need more time to talk with the state, Your Honor.
State, did you hear Mr. Merleader's announcement?
Yes, Your Honor, and we were made aware that Ms. Delaney had come in and paid that restitution, but I've not had time to look at everything, so we would agree to a reset.
Well, rather than a reset, what we're going to do is, since there's no contested pretrials, you've received discovery, you've received an offer. Court's going to set this for docket call on September 15th, and it gives you all additional time to try to resolve the case. Mr. Merleader, Ms. Delaney is delinquent $300 on her pretrial release, and we show that she has not reported since February. So I'm going to just order you to report to pretrial today, and you need to talk with them about your financial delinquency. And Mr. Merleader, I would expect that to be resolved before we attempt to resolve the case with the plea agreement.
Yes, Your Honor.
So once she signs, then she's to report to the pretrial release board, after which she'll be free to go. Mr. Schmidt, are you ready?
Yes, sir.
Are you ready? I'm sorry.
I'm ready. Mr. Hendon and Ms. Lenartz. In addition, I believe Francisco Zanella is here, and that is Mr. Manning's client. He's asked me to stand in. I don't think that he claimed that he got notice that he had been placed on the docket, and I think that has something to do with pretrial fees or something.
All right, we'll come back to that.
All right. And both of those are pleas, Lenartz and Hendon.
Sworn and ready to go?
Yes, sir.
All right, Mr. Hendon, CR 20-13. Come up to the podium, please, sir. All right, Mr. Schmidt, I see some modifications to the judgment where the fine's been marked out from 350 to 250. Is that right?
Yes, sir. Judge,
Then on the second page, it says 150.
Judge, the total fine should be $250. That was the negotiated fine. On the back, it said a $250 fine plus an additional $100 domestic violence fine. And I had spoken to Mr. Cox at the DA's office and asked if he would agree to reduce the fine as agreed to $150 and still include the $100 domestic violence fine, which totaled $250. So that's why the judgment has been interlineated, and the court cost sheet is reflecting the same.
He has the court cost sheet, right?
Yes, sir.
The state hasn't signed the admonishments. We'll need to get a signature on them.
Yes, sir.
And the state hasn't signed the certificate of discovery either. You want to proceed without the state signature on the certificate of discovery at this time?
Judge, I think that if the state would, on the record, state they intend to sign all those, then yes, we would like to proceed.
And I'll state on the record, we did not sign either document, but I will later today.
Thank you, Mr. Cox. All right, Mr. Hendon, if you raise your right hand, I'm going to place you under oath. Mr. Hendon, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Hendon, you are Alfonso Lamar Hendon, correct? And Mr. Hendon, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And Mr. Schmidt, if you could step away from Mr. Hendon. There we go. That way we can maintain our social distancing. And so, Mr. Hendon, you are represented by your attorney, Mr. Schmidt, is that correct? And are you pleased with his representation of you? And do you feel like you have sufficient time to talk with him about your case and have all of your legal questions answered? Is there anything that you have reviewed and signed that you do not understand? Okay. And Mr. Schmidt, do you believe Mr. Hendon to be competent today?
Yes, sir.
And you believe that he understands the nature and consequences of his plea agreement?
I do, Judge.
And you've explained to him all of his legal and constitutional rights?
I have.
All right, and Mr. Hendon, it appears to the court that you were originally indicted with a second-degree felony offense of aggravated assault with a deadly weapon. However, it appears that the plea agreement is that you would be pleading guilty to a lesser included offense, being a Class A misdemeanor, assault causes bodily injury of a family member, the family violence, that your recommendation from the state would be 60 days confinement in the Van Zandt County Jail, with you receiving credit for 1 day, a $250 fine, and you would be going into custody today to serve out the remaining part of your sentence. Is that your understanding of the plea agreement? Yours as well, Mr. Schmidt?
Yes, sir.
All right, Mr. Hendon, the range of punishment for a Class A misdemeanor is confinement in the Van Zandt County Jail not to exceed 1 year or 365 days, and a fine not to exceed $4,000. Any agreement or punishment handed down by the court must fall within that range of punishment. Do you understand that? And it appears that the plea agreement would fall within that range of punishment. All right, then Mr. Hendon, as to the Class A misdemeanor offense of assault causes bodily injury of a family member, a lesser included offense of aggravated assault with a deadly weapon, how do you plead? Guilty or not guilty? And Mr. Hendon, are you pleading guilty because in fact you are guilty and for no other reason? Has anyone threatened you, forced you, or otherwise pressured you to plead guilty? And you are pleading guilty because in fact you are guilty. All right, make sure you speak up so my court reporter can take down everything that you say. All right, court will accept Mr. Hendon's plea of guilt at this time. Mr. Schmidt, any objection to the admission of the stipulation of evidence that states 1?
No, Judge.
All right, court admits states exhibit 1, stipulation of evidence, and takes judicial notice of Mr. Hendon's judicial confession. Is there anything further from the state?
No, Judge, we'd rest and close unless the court wants a synopsis of the facts.
Yeah, the court will ask for that in a moment. Is there any concern with victim compliance in this?
With victim what, I'm sorry, Your Honor?
With compliance with the victim impact statement or communicating this?
No, Your Honor, we're in compliance with the code.
Is there any concern from the victim regarding the reduction of a charge in this case?
No, Your Honor.
Your Honor, I'd like to clarify something for the record. You asked Mr. Hendon if he was pleading guilty because in fact he was guilty for no reason. He did not understand the question and he responded to the court, no.
I heard you say that, and that's why I asked him again.
And we wanted to clarify that.
Yeah, I heard you say no, and that's why I asked him again if he was pleading guilty because in fact he was guilty of this offense. And then he said yes. He said no again?
He said no because he still didn't understand. That's why I'm bringing it to the court's attention now, so the court would like to ask him that question again.
Okay. Well, I heard you say no the first time, but I believe the second time he answered it affirmative. But you're saying he answered no twice?
That's
one would be yours.
So, Mr. Hendon, the court previously asked you if you were guilty of assault causes bodily injury of a family member, a lesser included offense. And I asked you if you were guilty of that offense because in fact, you are guilty of committing that offense and no other reason, meaning you're not pleading guilty before the court to get a certain sentence when in fact you're not guilty of the offense. So at this time, I'm gonna ask you again, are you guilty of committing this offense? All right, and has anyone threatened you, forced you, or otherwise pressured you to make you plead guilty to this when in fact that is not what you want to do? Okay, thank you, Mr. Schmidt. I appreciate it. I thought I heard it correctly the second time, but perhaps. All right, anything further from the defense, Mr. Schmidt?
No.
And Mr. Cox, you asked if I wanted a summation. I've got that. I've got the report here. I'll just peruse through the report.
Yes, sir.
All right, based on the court will follow the plea agreement in this case and state's recommendation. The court finds that there is sufficient evidence to convict Mr. Hendon of the lesser included offense of Class A misdemeanor assault causes bodily injury of a family member. Court hereby convicts Mr. Hendon of that offense, assesses his punishment at 60 days confinement in the Van Zandt County Jail. Court issues Mr. Hendon 1 day credit for time served on this matter. Court assesses a $250 fine, $290 court costs. The court orders Mr. Hendon to reimburse Van Zandt County $785. All right, Mr. Hendon is hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step up here to be fingerprinted by the bailiff. And then bailiff, he used to go into custody.
Yes, sir.
Mr. Schmidt, do you have the paperwork on the bottom? This is up here. Stephanie Lenard, CR 15383.
May I, Your Honor, prior to proceeding, Ms. Lenard is intending to plead. Her plea is to revoke and sentence her to 8 months in the state jail facility. I negotiated with the state and they agreed to allow Ms. Lenard to surrender her plea today and surrender herself on the 18th, which is 2 weeks from today, to give her an opportunity to get her child enrolled in school. I wanted to bring the court's attention to that prior to proceeding in the event that becomes an issue.
State's position.
That's correct, Your Honor. And we had the date wrong on the judgment. I believe Mr. Schmidt has interlineated on the face of the judgment. We have no objection to that either.
All right, so Mr. Schmidt, you have admonished your client the ramifications of her failure to appear if the court approves this agreement.
The judgment talked about it, but I would ask the court to admonish her again.
All right, Ms. Lenars, if you will, raise your right hand and place you under oath. Ms. Lenars, do you swear that the testimony you give to the court, that it will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Ms. Lenars, Mr. Schmidt has indicated that to the court that this agreement that you want the court to approve would not have you go into custody until Thursday, August 18th. If the court approves this and you fail to appear with your ID, a copy of this judgment on August 18, 2020, do you understand that could result in additional felony charges of escape? You understand that not only would a warrant be issued for your arrest, not only would you have to serve the sentence in this case, you would also be facing a potential felony prosecution for another offense that would carry a range of punishment of 2 to 10. You understand that? All right. Ms. Lenartz, you appeared before the court on October 27th of 2016 on the offense of driving while intoxicated with a child under 15 years of age. That's a state jail felony offense. The court reviewed the evidence, found that there was sufficient evidence to convict you of that offense. The court convicted you of that offense, assessed your punishment at 2 years confinement in the Texas Department of Criminal Justice, but suspended that sentence and placed you on community supervision for a period of 5 years. It was during that period of 5 years that the state filed its motion, the amended motion to revoke your community supervision. They filed that on February 11th of 2020. Have you had sufficient time to review that motion with your attorney, Mr. Richard Schmidt? Yes, sir. You feel like you've had enough time to review this motion and your case with him and have all of your legal questions answered? Yes, sir. And are you pleased with his representation of you? Yes, sir. Mr. Schmidt, does your client waive a formal reading of the state's motion?
We do waive.
All right, and it is your client's intent to plead true to all counts contained in the state's motion?
Yes, sir.
Those being 10 separate counts?
That's correct.
All right, Ms. Lenartz, then, and let me ask you too, Mr. Schmidt, do you believe Ms. Lenartz to be competent today?
I do.
You believe that she understands her legal and constitutional rights, and you've heard the court admonish her, and I believe you also admonished her that if the court approves this plea agreement, that she would be required to submit herself to the Van Zandt County Jail on August 18th, and you believe that she understands the consequences if she does not.
I do, Judge. We talked about the consequences in detail as far as her plea and ultimately the graciousness of the court and allowing her to surrender at a later date. So she not only understands that, but she's appreciative as well.
All right. All right, Ms. Lenartz, then as to counts 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10, as to each one of those counts, as contained in the state's amended motion to revoke, are those counts true or not true?
True.
And Ms. Lenard, are you telling me that those counts are true because in fact they are true for no other reason?
They are true.
And no one's threatened you, forced you, or otherwise compelled you to plead true to something that's not true, is that right? All right, the court will accept Ms. Lenard's plea of true. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true as states Exhibit A?
No objection.
Court admits states Exhibit A. Anything further from the state?
No, Your Honor.
Further from the defense?
No.
All right, court, having accepted Ms. Lenard's plea of true, takes judicial notice of her plea of true, admission of states Exhibit A. Based on that, the court will find that Ms. Lenard has in fact violated the conditions of her community supervision. Court hereby revokes her community supervision, assesses her punishment in accordance with the plea agreement in this case. Court orders her confinement in the Texas Department of Criminal Justice State Jail Division for a period of 8 months. Court orders her to pay the balance of her financial obligations. The court orders Ms. Lenard to submit herself to the Van Zandt County Jail on August 18, 2020 to begin her sentence. There's no time indicated on here. So I guess anytime that you show up, Ms. Lenard, you need to show up with a copy of your ID and this judgment. You'll need to show up with some type of legal ID, otherwise the Van Zandt County Jail is not going to let you come in and start your sentence. Okay? So you'll need to get that rectified before August 18th. Court also awarded Ms. Lenard's 15 days credit for the time that she has spent in jail on this cause towards her sentence. Mr. Schmidt, the clerk's brought me a new copy of the first page of the judgment. If you want to come view that, maybe just corrected the delineation.
Thank you, Judge.
All right, Ms. Lenard, you're hereby remanded to the custody of the Van Zandt County Sheriff so you can carry out the terms and conditions of your sentence. Have you step forward to be fingerprinted here, and then you're to report to the Van Zandt County Jail on August 18th, 2020.
Thank you, Your Honor.
Is that all you have, Mr. Schmidt?
Judge, I'm appearing on behalf of Mr.
Oh, that's right. All right, Mr. Zanella. CR 19-294, State versus Francisco Zanella. I believe that we are set for docket call today.
Judge, when I spoke with Mr. Manning earlier, he did not believe that it was on the docket today, but that thought that it's a compliance issue with pretrial release conditions. He's asked me to relay to the court that he would request that the matter be set on either another docket call, or he would also like to urge a motion to withdraw, which is on file with the court, have that matter set as well.
I see the motion to withdraw council filed on July 6th. We were set for docket call today. There's a notice of appearance form from July 7th. So Mr. Manning will need to be here to argue his motion to withdraw.
I understand, Judge. I think what his request is that, since Mr. Snell's here, that on the next setting, that motion to withdraw be set to be heard at that time. As far as today is concerned.
Yeah, court, I'll reset it for docket call, and we'll also take up his motion to withdraw as counsel. I don't have any docket notes that Mr. Zanella is in violation of pretrial release. I'm not sure what that's about.
And I'm not sure of the confusion either, Judge, but.
Will it be August 24th? Yes, sir. Ms. Huber, CR 2051. All right, Ms. Huber, if you will, raise your right hand and place you on oath. Ms. Huber, do you swear that the testimony you give to the court today that it will be the truth, the whole truth, and nothing but the truth? So if you got, all right, you may put your hand down. You are Destiny Nicole Huber, is that correct? And are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Murley. Are you pleased with his representation of you? You feel like you've had sufficient time to review the case with him, have all of your legal questions answered? Mr. Murley, have you explained to Ms. Huber her legal and constitutional rights?
Yes, Your Honor, and I'll put on the record that my client is competent.
Thank you, sir. All right, it appears that Huber was originally indicted to a second offense of delivery of a controlled substance or marijuana to a minor. However, it appears that the plea in this case is that she's going to be pleading guilty to a lesser included Class B misdemeanor offense of possession of marijuana less than 2 ounces, with a recommendation that a finding of guilt be deferred, with her being placed on 1 year community supervision and a $500 fine. Is that your understanding, Mr. Murley?
Yes, Your Honor.
That's your understanding of the plea agreement, Ms. Huber? All right, Ms. Huber, the range of punishment for a Class B misdemeanor offense is confinement in the Van Zandt County Jail for up to 180 days or 6 months, and a fine not to exceed $2,000. You understand that range of punishment? If the court ultimately approves this plea agreement and places you on community supervision, if you violate that community supervision and you are brought back before the court, the issue will not be whether or not you possess marijuana. In this case, on February 3rd, 2020, the issue for the court will become, did you violate your community supervision? And if the court finds that you violated your community supervision, the court could adjudicate your guilt, that means convict you of a Class B misdemeanor offense of possession of marijuana, and the court could revoke your community supervision and could assess punishment in the Van Zandt County Jail from 1 day all the way up to 180 days. You understand that? Then let me ask you then, Ms. Huber, to the Class B misdemeanor offense of possession of marijuana less than 2 ounces, how do you plead? Guilty or not guilty? Ms. Huber, are you pleading guilty because in fact you are guilty of that offense? Has anyone threatened you, forced you, or pressured you to plead guilty to something you're not guilty of? All right, the court will accept the defendant's plea of guilt. Mr. Murleader, any objection to the admission of States 1, the stipulation of evidence?
No, Your Honor.
All right, court admits States Exhibit 1 into evidence, takes judicial notice of Ms. Huber's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, based on the evidence in the case, the court will find that there is sufficient evidence to convict Ms. Huber of this offense. However, the court will follow the plea agreement. Court hereby defers a finding of guilt in this case. Court places Ms. Huber on 1 year community supervision. Court assesses a $500 fine, $270 court costs, and orders her to reimburse Van Zandt County $785. Ms. Huber, you have reviewed all of the conditions of your community supervision. Is that right? You know what's expected and required of you. And I told you what happens if you violate. Have I not? How old are you? How old? 18. The minimum age to be prosecuted as an adult in the state of Texas. So you've got a serious charge hanging over your head. You have up to 6 months in the county jail. You understand that? You intend to take your conditions of community supervision seriously and to comply? It means you're gonna have to be working, you're gonna have to have a job, you're gonna have to pay your fines, your fees. You owe Van Zandt County. You understand that? You're gonna be drug tested, can't be smoking weed, can't be drinking alcohol. You gotta show up when they tell you to show up, report when they tell you to report, gotta stay clean. Gotta do everything that's included in these conditions of community supervision. You understand that? I wanna have this conversation with you now because the next conversation, if you violate, will not go as well. You understand? So I've done my job as a judge. The state's done their job as the prosecutors. Mr. Murleader has done his job as your defense attorney. There's only one person who's left to do their job, and who is that? You. Okay? All right, Ms. Huber, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you come up here with my bailiff to be fingerprinted, after which you're to report to the probation department through these doors. Maybe. We'll see how it goes.
Thank you, Judge.
Mr. Murley, on Mr. Linden, I have a note that he's in county jail.
That's correct, Your Honor. We were set initially here for pre-trial, and I was going to announce ready for trial, but Mr. Van Linden is not here, and I think the state already, or sorry, his bondsman already went off his bond, and there's also a warrant attached to him for this case in Tarrant County Jail. I checked yesterday night. So,
so you think that the court has already issued the release of surety?
I saw it on the Tarrant County Jail's website, but I didn't get a surety signed from the court from what the bondsman filed with their 1715 affidavit.
Verify that. Do we know charges?
I saw assault misdemeanor on the jail record. He has no prior, so they wouldn't be able to enhance it for that. He does have a different felony prior, but not assault on allowance.
I do see the request for a detainer, but I don't show that being presented to the court. Says the detainer has been placed on the defendant.
That's what I saw in Tarrant County, Your Honor.
All right, they indicate they have a hold on it. I guess they've gotten a magistrate's signature on that.
May I approach, Judge? What did I show you?
I see the sheriff's office, and they submitted a representative of the sheriff's office indicated on July 30th that they received the surrender of principal for forfeiture and that a detainer has been placed on the defendant. There was not a request for a caveat. It's not signed by the judge or magistrate, so we'll leave them with their detainer then. I want to issue a forfeiture. Okay. All right, so we'll need to set this though, so it doesn't fall off the court's docket. We'll set this for September 15th for pre-trial and status. Custody status.
Your Honor, if I get a reset notice to Mr. Vander Linden where he's incarcerated and he signs requesting a jury trial, would the court accept that and put us on docket call? For jury selection?
If he's still in custody?
If he's still in custody. And the reason I say that, yes. I just don't want to waste the court's time with more pretrial. I've given him counsel and I've explained to him the state's evidence and given him an opportunity to review it. Both times when this case was filed, he has rejected the plea offers from the state.
Okay, well, I'll tell you what, let's do this. We'll set for docket call then on September 15th. Court will find that there's no contested pretrial motions The defendant has received discovery,
Yes.
has received an offer, has rejected the state's offer. So we'll set up a docket call and then I can have a final announcement. We'll either have them here or if by chance we can set up a Zoom with Tarrant County. If you check with them and they have that capability, they can do that as well.
Yes, ma'am. Does the state hear that? I saw Zoom going in and out.
State, did you hear it?
I didn't hear the date, Judge, but I heard about the reset to docket call.
Docket call September 15th.
Okay, we'll be ready, Judge.
And we'll check on his custody status with Tarrant County at that time as well. And if there's a request for a bench warrant, then we'll need to file that with court. All right, anything else, Mr. Murley, here this morning?
Nothing else, Judge. That's all I have in this case.
Do you have anything this afternoon?
I don't think so, Judge. I think you already said that.
I'll show you got John Williams, John Charles Williams.
I do.
Set for arraignment.
I will file a waiver.
Okay. Either get that filed or
I'm going to
get out there first and log it out.
I'm going to go see him in jail right now.
Okay. Ms. Beasley, are you ready, Ms. Taylor?
I am, Your Honor.
Ms. Taylor, the front of the podium, please, ma'am. CR 20-142. Believe that we're set for arraignment today.
That is correct, Your Honor. If I may, Ms. Taylor's first name, Rosalind, is misspelled. In the indictment, it is supposed to be Rosalind.
So the A and the I are flipped.
Split, yeah, yes.
In the second part of it.
Yes.
Did you hear that, State?
I did, Judge, and we would make an oral motion to amend the indictment, and if it's okay with the court, we'd ask that the court interlineate the correct spelling of the defendant's name on the docket in the court's file.
No objection.
All right, court will state's oral motion to amend the indictment to reflect the correct spelling of the defendant's first name, Rosalind, Rosalind. All right, and has Ms. Taylor had an opportunity to review that document with you? Does she waive a formal reading of the indictment?
She does, Your Honor, and wishes to enter a plea of not guilty at this time.
She understands the charge of burglary of habitation?
She does, Your Honor. She understands the punishment range and asks for a pretrial setting.
All right, court will set Ms. Rosalind, Ms. Taylor, do you believe, Ms. Beasley, that if I set it on September 15th, that that's sufficient time to file your pretrial motions?
I'm hoping that it will be, Judge.
Okay. All right, we'll set this then for pretrial on September 15th at 9 a.m.
Make sure you excuse, Your Honor.
Yeah, thank you, sir. Thank you, Ms. Taylor. All right, Ms. Beasley, before I bring Mr. Lane up, are we ready? We not ready?
Your Honor, he wants to make a request to withdraw his plea that he entered previously today and wishes to retain his own lawyer. It's my understanding from talking with probation that he's already paid $965 towards my attorney's fees. I submitted a bill today because I expected to be able to do the plea today. I believe the court has it in front of me. I think that's $1,200. I could be wrong, but he has explained to me that he should be able to finalize his play, pay my court-appointed attorney's fees by this afternoon, right after lunch.
You go verify what it's saying.
He wishes to retain his own private attorney.
All right, Mr. Lane, come up to the podium. Is he currently appointed on this case?
I'm court appointed, Your Honor.
All right, Mr. Lane, I put you under oath earlier. You understand that you're still under oath at this time?
Yes, Your Honor.
All right, I want you to listen to me for just a moment, okay? You're on my docket and you have you have 4 charges. You have a 3rd degree evading arrest and detention with a vehicle. You have a tampering with a governmental record, also 3rd degree. You have unauthorized use of a vehicle, state jail felony. And you have a tampering with governmental record. So I see 4 charges here, and the plea agreement that was before the court was that 3 of those 4 were going to be dismissed. And the final charge was going to have a 2-year sentence for tampering with a governmental record, intent to harm or fraud. You came before the court and you told the court that you were indigent and you requested the court to appoint you an attorney. And the court did it. The court appointed Ms. Beasley, who's here with you in court. And I know of no less than 2, possibly 3 times that we have reset this case to allow you, due to health issues, I believe a baby, right?
Yes,
The court has reset this thing multiple times. Each time Ms. Beasley has come to court, has argued for the court to reset, to accommodate your schedule. The state has agreed. Everyone has done what they're supposed to do to get us here to this point. Ms. Beasley has indicated to me that you'd wanted to plead guilty and resolve these things and put them behind you. And the court accommodated that. And we've gotten here today. And I've heard you tell me that you're guilty of this offense, but that you disagree with the sentence. Now, you knew coming in today what the recommendation was. You knew what the sentence was. So how come you stood before the court today and we started this process and you told me that you're guilty, and now you're telling me you disagree with the agreement that you reached with the state? This is not a punishment that I've handed down. This is nothing that I've done. This is something that you've done with the state, and you've had all this agreement reduced to writing, and you've gone through here and you've signed it and you said you've understood it and you put it before me and you told me, Judge, this is what I want to do. And then when I go through the extra steps of making sure that this is what you want to do, now you tell me you don't want to do it. And now you're telling me that you don't even want your court-appointed attorney that you asked for to represent you anymore, and that you want to hire your own attorney and withdraw your plea. Is that right?
Yes, Your Honor.
And why should I allow Ms. Beasley to withdraw? And why should I allow you to hire another attorney?
Your Honor, I hadn't had the money at the time. I have the money to go and purchase a lawyer, and I just don't believe I'm guilty of that. The only reason I said I was guilty is because I didn't want them charges on me. I was scared because I've been in trouble before, and I didn't want to risk all this time whenever I would just become a father. I'm trying to do what's best for my family, and honestly, I've changed a whole lot. I've changed so much, and I just feel like, there's
Well, listen, I don't want to go into a punishment hearing and you try to argue your way out of whatever sentence may come your way. I don't know. I don't want to do that. That's not the time. It's not the time to do that.
Your Honor, if I could.
Go ahead, sir.
Your Honor, if Mr. Lane wants to hire his own attorney, obviously he can. However, he needs to know that after today, the state's offer will no longer be on the table. There will be no more offers from the state after today, at which point Mr. Lane can have 4 different jury trials and the state gets 4 bites at the apple. So he needs to know that going forward.
You understand that? The state has indicated that if you pass the plea agreement today, and the court will allow you your own attorney. The state has indicated on the record that they're withdrawing their offer of 2 years and dismissing all the other charges.
Yes, Your Honor.
And you understand that the range of punishment for the other charges, 2 of them are third-degree felonies where you could be facing up to a maximum of 10 years.
Yes, Your Honor.
And the other one, I believe, is a state jail felony offense where you could be facing up to 2 years confinement in the state jail. And you understand that if the state tries each one of these cases separately, then any sentence you get in each case will be stacked one upon the other. You understand that?
Yes, Your Honor.
This is what we're going to do then. I'm going to allow you to withdraw your plea of guilt. I show that you owe, Miss Beasley has submitted a bill of $1,200 for the handling of all of your cases. I do show that you have paid in $965. That shows that you owe Van Zandt County $235. Okay? So what we're going to do is I'm going to reset this case for docket call on September 15th. Between now and September 15th, Ms. Beasley is still your lawyer. She is still your lawyer until you hire an attorney, and that attorney files a motion to substitute, and you pay your pretrial release officer $235 to satisfy the $1,200 that is owed Ms. Beasley. Once those 2 things happen, then I will grant any new attorney's motion to substitute as counsel. Understand?
Yes, Your Honor.
Do we have any other pretrial release issues with Mr. Lane that you're aware of? All right, Mr. Lane, so you're clear of what is going to happen after today.
I'm coming back to 15.
You're coming back to 15, but before you get here, you will need to have pay $235 to the pretrial release department, and you will need to have another attorney file a motion to substitute. Don't come back here on the 15th expecting that to happen. Okay, don't come in and say, I need more time. Don't come in and say, I'm gonna try to hire one later today. On the 15th, when you show back up, that attorney needs to have already filed a motion to substitute. That way, on the 15th, I can tell them that we're set for docket call. Either you're gonna enter into a plea agreement, or we're gonna set it for trial. We're not going backwards in the case.
I understand.
So when you speak with the attorney, you need to let them know that the state has indicated that there's no offer, because the amount that they're probably gonna charge you when they know it's a jury trial, probably going to be more than if they thought they could work out the case. So you need to be aware of that. All right. All right. Free to go. We'll see you back on 15. All right, Ms. Beasley. Can I give you these 2 papers back? And I'm gonna go ahead and sign this. Well, actually, I'm gonna hold on to it. I'm gonna hold on to it, because if he doesn't file a motion, are you gonna file a motion to withdraw regardless, or you wanna wait to see if he files a
I'm
motion?
probably gonna file a motion to withdraw.
All right, file your motion to withdraw here. Go ahead and attach that to it, and then once that's filed, I may table it to see what happens with him.
Yes, sir.
If he gets a lawyer, then obviously I'll sign it and we'll move forward. If he doesn't get a lawyer, I may leave you on there and we may discuss this again. Because I haven't heard any reason to actually withdraw. Or we could take that up on the 15th if he doesn't do what he's supposed to do, which I highly suspect he will not. All right, so state 9:15, and that's going to be set on Dr. Hall, Mr. Lane, attorney status. All right, I'm going to have the following names called. Tanya Red. Tanya Red. She's on page 2 here.
Yes, sir.
Halfway down the page. Tanya Red.
Second page.
Second page. Halfway down. Tanya Red, Steve Green's. The document may be different than mine.
It is different than yours.
If it's by attorney, it's Steve Green. It's alphabetical. What you read.
Oh, okay, they're doing that now, okay. It's been a while since I've been up here. Got it, Judge, go ahead.
And Christopher Booker. Attorney is Ian Thompson. Also, Jay Bruner. Attorney is Jeff Wood.
He's got 2 cases, yes, sir. I still haven't found the second one you mentioned. What was the name again?
Jay Bruner.
No, sir, got that one. Who's the one prior to that?
Booker, Christopher.
Christopher Glenn Booker. Attorney is Ian Thompson.
Stand by, Judge. Got it? 2 cases? Yes, sir.
I believe that's all.
3 names?
3 names.
Yes, sir.
And I believe that Mr. Vanderlinden shows that the sheriff's office has a hold on him. Doesn't show that a KPS has been issued. They show they have a hold on him, so I'm not gonna forfeit the bond, so just those 3 names.
Band delay, we don't call.
No. So Tanya Red, Christopher Booker, Jay Bruner.
Yes, sir, got it.
All right, state, I'm gonna call those and find their bonds. I'm gonna forfeit their bonds, issue KPSs, and I'll see you at 1:30. Thanks. You have a good day.